चैप्टर 4 है। चैप्टर 4 इज जनरल एक्सेप्शन। सेक्शन 14 से लेकर 44, 14 से 44। One chapter third of the BNS deals with D general exceptions. Question number 2 है general exception of BNS limit and override offenses and penal provision of the Sanhita and comprises of the following sections. 14 से 44, 14 सेक्शन 14 से 44 है जनरल एक्सेप्शन। The maxim ignorantia juris non excusat. Ignorantia juris non excusat means ignorance of law is no excuse. अगर आप लॉ नहीं जानते हैं तो इसका कोई एक्सक्यूज नहीं होगा। मान लीजिए आप किसी कंट्री में जानते हैं और वहां पे कोई काम करना ऑफेंस है लेकिन आपके कंट्री में नहीं था, तो ये इससे आप एक्सक्यूज नहीं दे सकते कि हमको लॉ नहीं पता था तो हम बच जाएंगे, ऐसा कोई एक्सक्यूज नहीं होगा। चौथा है इग्नोरेंसिया फैसिट एक्सक्यूसैट। मैक्सिम मीन्स इग्नोरेंस ऑफ फैक्ट्स एंड एक्सक्यूज। फैक्ट का जो इग्नोरेंस है वो एक्सक्यूज में आ जाएगा लेकिन लॉ का एक्सक्यूज नहीं आएगा। द मैक्सिम इग्नोरेंसिया फैसिट एक्सक्यूसैट रिलेट्स टू सेक्शन 14 ऑफ द BNS। सेक्शन 14 ऑफ द BNS। छठा है सोल्जर फायर्स ऑन ए मॉब बाय ऑर्डर ऑफ हिज superior officers in conformity with the commands of law. A has committed no offense. His defense comes under section 14 of the BNS क्योंकि उसने अपना ड्यूटी किया है और ड्यूटी करते वक्त जो काम होता है वो ऑफेंस में नहीं आएगा। सातवां, ए एन ऑफिसर ऑफ ए कोर्ट बीइंग ऑर्डर्ड बाय द कोर्ट टू अरेस्ट Y and after due inquiry believing Z to be Y arrest Z, what mistake has been committed by A? Mistake of fact। अब A को अरेस्ट करने गए और B को अरेस्ट कर लिए तो ये दिस इज मिस्टेक ऑफ फैक्ट, इसको माफ कर दिया जाएगा। एक्ट ऑफ जज एक्ट डन परसुएंट जजमेंट ऑफ द कोर्ट। पहला है which of the following section of the BNS provides that act done in pursuant to judgment or order of a court is not an offense। pursuant to judgment or order of a court is not an offense। सेक्शन 16। दूसरा में है which one of the following statement is correct? A hangman who hangs the convict pursuant to the order of the court is exempted from the criminal liability by virtue of C। सेक्शन 16 के तहत कोई हैंगमैन है जो कि फांसी दे रहा है तो वो किसी को डेथ पेनल्टी जो है वो कोर्ट के ऑर्डर पर एग्जीक्यूट कर रहा है तो ये कोई ऑफेंस नहीं कर रहा है। ये भी किसी को किल कर रहा है लेकिन ही इज फॉलोइंग द ऑर्डर ऑफ द कोर्ट, मींस कोई ऑफेंस नहीं कर रहा है। Which of the following section of the BNS provides that nothing is an offense which is done by a judge when acting judicially in exercise of any power which is or which in good faith he believes to be given but to him by law। अगर कोई गुड फेथ या जुडिशियल कैपेसिटी में कोई काम कर रहा है तो वो कोई ऑफेंस नहीं होगा। सेक्शन 15 बोलता है एन एक्ट which is done by a judge when acting judicially in exercise of any power which is or which in good faith he believes to be given to him by law, then act of judge is not an offense। पांचवा में है which of the following section of the BNS provides that nothing is an offense which is done by any person who is justified by law or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be justified by law in doing it। Section 17 acts done by accident। Which provision of the BNS says nothing is an offense which is done by an accident? सेक्शन 18 कोई भी एक्ट अगर एक्सीडेंट से हो गया तो वो ऑफेंस नहीं होगा। दूसरा में है which of the following is not an essential ingredient of defense of accident under section 18 of the BNS? The act need not to be done with proper care and caution। A is at work with a hatchet. The head flies off and kills a man who is standing nearby. No want of proper caution on the part of A। His act is excusable। Excuse कर दिया जाएगा, not an offense। B is drowning an insensible A in order to save his life pulls him out of the water with a hook which injures him। A is guilty of D of no offense। कोई डूब रहा है उसको बचाते हुए उसको चोट लग गया वो कोई ऑफेंस नहीं होगा. ए वर्कमैन थ्रोज अ स्नो फ्रॉम ए रूफ गिविंग वार्निंग ए पासर बाई इज किल्ड, द वर्कमैन इज नॉट गिल्टी सिंस डेथ वाज एक्सीडेंटल. विच ऑफ द फॉलोइंग proposition is correct? D. All the above. Nothing is an offense which is done by a judge when acting judicially. Nothing is an offense which is done by any person who is justified by law. Nothing is an offense which is done by any person by accident. एक्सीडेंट से हो, जस्टिफाइड बाय लॉ हो या एक्टिंग जुडिशियली हो तो ये नहीं होगा. नेसेसिटी. Which provision of the BNS provides for the doctrine of necessity? Doctrine of necessity. Section 19. Doctrine of necessity. In which of the following cases necessity under section 19 of BNS cannot be pleaded as defense? B. Prevention of harm to accused at the expense of an innocent person. तीसरा, necessity as a defense cannot be claimed when the act has been done with inherent risk of causing harm. The case of R versus Dudley and Stephen is related to the defense of necessity. R versus Dudley and Stephen. Jed is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Jed but not intending to kill Jed and in good faith intending Jed's benefit. A's bullet gives Jed a mortal wound. A has committed no offense क्योंकि इसने बचाने में वो काम किया था. Acts of child. पहला में हो गया the acts of child constituting general exceptions under BNS are mentioned in सेक्शन 20 से 21. 20 से 21 में है डॉली कैपेक्स और डॉली इन कैपेक्स. नथिंग इज एन ऑफेंस विच इज डन बाय चाइल्ड अंडर 7 years. अंडर 7 years के एज में ऑन लीगल मैक्सिम क्या रहता है इसका? डॉली इन कैपेक्स. 7 साल से बच्चा को कोई नीचे जो है उसको सूद बूद नहीं रहता है, मतलब कि वो उसका जो है वाइटल्स डेवलप नहीं है, मतलब उसका दिमाग सही से डेवलप नहीं है एज ए ह्यूमन बीइंग. सो वो क्या कर रहा है उसको खुद नहीं पता, तो उसका कोई ऑफेंस नहीं माना जाएगा. The principle of Dolly in capex under BNS is an exception to criminal liability in which one of the following sections? Section 20 में है Dolly in capex. Which one of the following provision of the BNS says nothing is an offense which is done by the child under 7 years of age? Section 20. पांचवा में nothing is an offense which is done by a child under 7 years. छठा में है which one of the following is presumed under law to be Dolly in capex to commit a crime? Child under 7 years of age. Section 20 of the BNS deals with the following. Absolute immunity. Immunity प्रदान करता है. Which section of the BNS provides that nothing is an offense which is done by a child above 7 years of age and under 12 years of age who has not attained sufficient maturity of understanding to judge nature and consequence of his conduct on the occasion. मतलब कि 7 से 12 साल का बच्चा जो होगा उसका मैच्योरिटी चेक किया जाएगा कि वो मैच्योर इनफ है कि नहीं है. अगर नहीं है तो उसको सजा नहीं होगा. कौन सा सेक्शन में कहा गया? सेक्शन 21 ऑफ द BNS. अनसाउंडनेस ऑफ माइंड एंड इंटॉक्सिकेशन. पहला में फर्स्ट क्वेश्चन, विच सेक्शन ऑफ द BNS प्रोवाइड्स द डिफेंस related to acts of person of unsound mind? Section 22. Which expression has been used under section 22 of the BNS? Unsoundness of mind. Nothing is an offense which is done by a person who at the time of doing it was of unsound mind. He is unable of knowing the nature of the act. Insanity is incapable of knowing the nature of act committed. In which of the following wild beast test was propounded? R versus Arnold. R versus Arnold में था wild versus wild beast test. The maxim non compos mentis. Non compos mentis means not of sound mind, not of sound mind. Non compos mentis, not of sound mind. Which type of insanity of the following is a ground for exemption from criminal responsibility? Legal insanity. Section A में है nothing is an offense which is done by a person who is at time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act. Mistake of fact is good defense and mistake of law is no defense. Both A and R are correct, but R is not the correct explanation. Which of the following case lays down the principles relating to the defense of unsoundness of mind? मैकनोटन केस जो है अनसाउंडनेस ऑफ माइंड, अनसाउंडनेस ऑफ माइंड को कौन बोलता है? मैकनोटन केस. Which section of the BNS deals with the defense of involuntary intoxication? Section 23. The defense of intoxication is not available where the intoxication is voluntary. अगर खुद पी के कुछ कर रहे हैं, चाहे इंटॉक्सिकेट कर रहे हैं, तो that is not defensive. Which of the following is the leading case on intoxication? Leading case कौन सा है intoxication का? Director Public Prosecution versus Beard. Consider the following statement: the accused at the time of committing the act because of intoxication which was administered to him without his knowledge or against his will is incapable of knowing the nature of the act, that the act is wrong or contrary to law, that the act is immoral or wrong, that the act is of nature which may be ignored. To claim the benefit of Section 23 of the BNS, which of the above need to be proved? One or two. The nature of the act, that the act is wrong or contrary to the law. Which section of the BNS deals with the voluntary intoxication? Section 24. The maxim non volenti non fit injuria has been incorporated in which section of the BNS? Section 25. X, a surgeon amputates the right hand index finger of Y, a 14-year-old beggar, with Y's consent and in good faith that this would enable Y to get more amps. X is not exempted from criminal liability as the act done was not in good faith within the meaning of the BN. A and Z, तीसरा में A and Z agree to fence with each other for the amusement. This agreement implies the consent of each to suffer any harm which in course of such fencing may be caused without foul play. A, while playing fairly, hurts Z and Z as a result dies. A is liable for no offense. Which section of the BNS provides for the defense related to acts done in good faith for benefit of child or person of unsound mind or by consent of the guardian? Section 27. Which section of the BNS deals with those conditions when consent is said to be not free consent? Section 28. Consent is said to be not free consent. With reference to Section 28 of the BNS, consent of child means the consent given by a person who is under 12 years of age. In which section, Satwa ma'am, in which section of the BNS the words good faith has been used? Section 28. Under BNS, the defense of consent is not available in cases of consent to cause death or consent to cause grievous hurt. किसी को अगर कंसेंट देते हैं कि आप हमको डेथ कर सकते हैं या ग्रीवियस हर्ट कर सकते हैं, तो दिस consent is not available. Consent given by a child below dash years of age is not deemed as consent under Section 28 of the BNS. 12 साल के नीचे दिए गए कंसेंट को कंसेंट नहीं माना जाएगा. In which of the following case consent is free consent? Consent is given by a child who is above 12 but below 14 years of age. फ्री कंसेंट कम माना जाएगा? above 12, below 14 years. 11 में है which section of the BNS provides for defense related to acts done in good faith for the benefit of person without consent? Section 30. The object of Section 30 of the BNS, protection of medical practitioner. Section 30 जो BNS का ये protection to the medical practitioners देता है. 13 में है Z is carried off by a tiger. A fires at the tiger, knowing it too likely that the shot may kill Jed. But he does it in good faith, intending to save Jed. A's bullet gives Jed a mortal wound. Which one of the following statement is correct? A can take the defense under section 30 of the BNS dealing with the acts done without consent. 14 में है A is a surgeon. Sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply to the child's guardian. A performs the operation in spite of entreaties of the child. In good faith for the child's benefit, the child died. A has committed no offense. Jed is thrown from his horse and is insensible. A surgeon found sight that Jed requires to be trepanned. A not intending Jed's death but in good faith for the Jed's benefit performs the trepan before Jed recovers his power of judging for himself. Choose the correct statement. A has committed no offense. Which section of the BNS provides for defense related to communication made in good faith? C. Section 30. A surgeon in good faith communicates to a patient his opinion that he cannot live. The patient dies in consequence of the shock. A is guilty of नो ऑफेंस, क्योंकि ये कम्युनिकेशन मेड इन गुड फेथ था, क्योंकि डॉक्टर का काम है बताना, और डॉक्टर नहीं बताएगा तो कौन बताएगा? अगर बता दिए कि हाँ आपको ये बीमारी है और आप इससे मर जा रहे हैं, तो दिस इज नॉट एन ऑफेंस. एक्ट्स कंपेल्ड बाय थ्रेट्स. Which section of the BNS is related to defense in case of acts to which a person is compelled by threats? Section 32. Section 32 of the BNS has no application in case of murder or offenses against state punishable with death. A is a blacksmith, is seized by a gang of dacoits and forced by threat of instant death to take his tools and to force the door of B's house. The dacoits, 10 in number, loots B money and jewels and kills B's son. A is not guilty of any offense. अगर कोई लोहार है उसको उठा के लेगा किसी का घर का ताला तोड़ने, चाहे किसी सेफ का ताला खोलने के लिए, तो जो डकैट्स है वो जिम्मेदार होंगे, ना कि ये ताला चोर होगा, क्योंकि इसको भी मारेंगे. चौथा में एक्स वॉलेंटरली ज्वाइंस ए गैंग ऑफ डकैट्स. द हेड ऑफ द गैंग ऑर्डर एक्स टू किल वाई, otherwise X would kill. X kills Y in order to save his life. Which one of the following statement is correct with regard to the liability of X? X is liable because where a person joins a gang voluntarily, knowing the character of the gang, then threat cannot be defense. मतलब आप ऐसा गैंग ज्वाइन कर लिए हैं डकैती का, और आप कहेंगे कि हम यहाँ डकैती करेंगे, तो डकैत बनोगे तो वहां पे मर्डर चोरी ये सब करना ही पड़ेगा. तो यू नो द कॉन्सिक्वेंस, और आपने वॉलंटरली ज्वाइन किया था गैंग, और बाद में आपको जबरदस्ती से मर्डर करवाया गया या चोरी करवाया गया, तो आप ये नहीं कर सकते कि हाँ हमको जबरदस्ती बोला गया कि हाँ हमको चोरी करो. You will be liable for that. Trivial acts. Act causing slight harm is an no offense if that harm is so slight that no person of ordinary sense and temper would complain of such harm. The maxim de minimis non curate lex. De minimis non curate lex. De minimis non curate lex is related to which of the following section of the BNS? Section 33. The maxim de minimis non curate lex is foundation of which general exception under chapter 3rd of the BNS? Act causing slight harm. Which one of the following conclusion can be drawn from the maxim de minimis non curate lex? Trifling acts do not constitute an offense. Trifling acts do not constitute an offense. Private defense. Nothing is an offense which is done in exercise of the right of private defense has been provided under section 34 of the BNS. Private defense. The right of private defense is based on the natural instinct of self-protection. Thank you.